Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. Now, contract law is built on a very simple principle. People should only be bound by agreements that they freely choose to make. But what happens if somebody signs an agreement because they were pressured into it, or threatened, or manipulated by somebody they trusted? At what point does persuasion become pressure? And at what point does pressure become legally unacceptable? And that's exactly what today's video is about. So whenever you see a problem that seems to suggest duress or undue influence, ask, did this person genuinely consent to the agreement? Because if the answer is no, the contract may be vulnerable. Now, in our previous video, we've looked at misrepresentation, and there the problem was someone was persuaded into a contract by something that wasn't true. Today, the problem is different. The concern isn't deception, it's pressure. Now, the legal effect is what we need to start with, and both duress and undue influence have the same effect. They make the contract voidable, not void, voidable. This means the innocent party has a choice. They can affirm the contract or rescind it, and the remedy is rescission, and there are no separate damages remedies available when this occurs. So the real issue is whether the contract should be unwound. Now let's begin with duress. In simple terms, duress involves illegitimate pressure that forces somebody into an agreement. Historically, this involved threats of violence. Today, the courts are more likely to encounter economic duress. And this is where somebody uses unlawful or illegitimate pressure to force a commercial concession. The classic example is, pay me more money or I won't perform the contract. Now, it's an important point to mention here. Not all pressure is unlawful. Business involves pressure all the time. Negotiation involves pressure. Competition involves pressure. The law does not interfere with normal commercial bargaining. And this brings us to the idea of what is legitimate commercial pressure. So examples could include refusing to offer a discount, negotiating a higher price, deciding to trade elsewhere, choosing not to enter a contract. These may be tough, but they are not usually duress. So what makes it duress? Well, the courts focus on three key questions. First, was there pressure that left the victim with no practical choice? Second, was the pressure illegitimate? Thirdly, did the pressure cause the agreement? All three elements are important. So let's look at them in a bit of detail. So no practical choice. This doesn't mean that there was literally no choice. Instead, the question is, did the victim have a realistic alternative? A party faced with commercial ruin may technically have a choice, but in reality, that choice may not be meaningful. When we then come to illegitimate pressure, this is usually the most important element. The court looks at things such as threats to breach existing contracts, bad faith conduct, improper demands. The pressure must go beyond ordinary commercial bargaining. Finally, did it cause the agreement? The pressure does not need to be the only reason, but it must be a significant reason. If the agreement would have been made anyway, any claim would fail. Now, why is duress important? Well, because commercial contracts are often renegotiated. One party suddenly demands more money, the other agrees. The question becomes, was that a legitimate variation, or was that variation extracted through duress? And the practical consequences of this is that usually only the variation is affected, not the entire contract. So the court may simply unwind the additional concession that was obtained through improper pressure. Now we need to move to something different, undue influence. Now, unlike duress, undue influence is not really about threats. Instead, it concerns abuse of influence. And the core idea here is that some relationships naturally involve trust and confidence. And if one party exploits that relationship unfairly, the law may intervene. And that intervention is called undue influence. So what makes it different? Well, with duress, we look for pressure. With undue influence, we look for influence that has become improper or influence that has been abused. So let's have a look at actual undue influence. This is where improper influence can actually be proven. The court examines the facts and concludes that one party unfairly dominated the other's decision making. Now, actual undue influence can be very difficult to prove. Conversations usually happen in private, evidence can be very limited, and that's where a second category therefore exists, known as presumed undue influence, and this is often much more important for SQE purposes. The courts may presume undue influence where two conditions exist. The first condition is there must be a relationship of trust and confidence. Now, some relationships automatically satisfy this requirement. For example, solicitor and client, doctor and patient, religious advisor and follower. Other relationships do not have this automatic presumption, but trust and confidence can still be proven. Examples would include spouses, partners, close family members. The question is, did one person genuinely place trust and confidence in the other? Then let's get to the second condition. The transaction must call for an explanation. In other words, why would a reasonable person enter this transaction? If the arrangement appears unusual, risky, or disadvantageous, it may call for explanation. Now, once both elements exist, so this relationship of trust and confidence and the transaction calling for an explanation, the court may presume undue influence and the burden then shifts. So can this presumption be rebutted? Yes. One of the most important ways is through independent advice. So if the weak party receives proper independent advice, it becomes much harder to argue that influence was improperly exercised. Now we come to the most heavily tested area, known as third-party problems and often known as the bank cases. So let's look at the typical scenario. So imagine a spouse wants a business loan. The bank demands security. The family home is offered as security. The other spouse signs the paperwork. Later, the business fails. The lender seeks possession of the home. The spouse then claims, I only signed because of my partner's undue influence. Now, there are two innocent parties, the spouse and the bank. Who should the law protect? Well, the court asks, was the lender put on inquiry? In other words, should the lender have realised there was a risk of undue influence? Now, when a lender is put on inquiry, generally this occurs where the relationship is non-commercial and the transaction is not obviously for the joint benefit of both parties. Those circumstances should alert the lender to potential risk. So what must the lender do? Well, the lender must take reasonable steps to ensure that the surety understands the transaction, and this usually means independent legal advice. If proper independent advice is obtained, the lender is generally protected. Now, why does this matter? Well, because the law is trying to balance competing interests. On the one hand, people should not be manipulated into dangerous financial commitments. On the other, lenders must be able to rely on security arrangements in ordinary commercial life. So what's Bowdie's bottom line? Well, every duress and undue influence problem starts with one question. Did this person genuinely consent to the agreement. If pressure was applied, consider duress. Ask, was there no practical choice? Was the pressure illegitimate? And did it induce the agreement? If influence was abused, consider undue influence. Ask, was there a relationship of trust and confidence? Does the transaction call for explanation? Has the presumption been rebutted? And remember, misrepresentation is about being misled, duress is about being pressured, and undue influence is about being manipulated by someone you trusted. All three undermine genuine consent, and remember, genuine consent lies at the heart of contract law. Thanks for watching this episode of Bowdie Shorts. Please see other videos in the contract law playlist available now on our YouTube channel.